Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. You know what? This week I'm going to use the top of the episode to congratulate my mom. While it's not immigration news, the Florida Supreme Court just confirmed that both abortion rights and recreational marijuana will be on the ballot this November in Florida, where my parents live and where I was reared. And that is because, to paraphrase the Florida Supreme Court, both issues received enough signatures to get on the ballot, and the proposed amendments passed Florida constitutional muster, even past a bench that many feared would be adverse to both issues. All of that is due in no small part to the hours of volunteer work that my retired labor and delivery nurse mother and others like her have done over the last year in the hot, rainy, muggy, and generally hostile South Florida swamp to inform residents of what's at stake, what the proposed amendments mean, and to secure signatures. Awesome work, Mom. I know how much this has all meant to you. Still not coming home to live in Florida, though. Also, because it's been a while, well, the patrons of the show keep the podcast going, and I appreciate every one of you. Like, for example, Amanda Doom in Dallas, who besides having one of the best names in immigration, also saved my butt last month with a pretty absurd situation in her part of the country. Thanks a bunch, Amanda, and very excited to again speak with your wonderful chapter soon. Maybe I'll talk about one of these 4 cases. Probably not, but I'll do it now. Starting off with United States v. Hansen, published by the Ninth Circuit on April 3rd, 2024. This case comes to us on remand from the Supreme Court, episode 166. Mr. Hellman Hansen is likely a U.S. citizen and, quote, ran an organization that purported to help undocumented immigrants become United States citizens through adult adoption, end quote. Seems like a lot of what he and the organization was doing was fraudulent. He was convicted of many things, including fraud, and lots of those convictions stood on appeal. At issue here are the convictions for encouraging or inducing a non-citizen to come, enter, or reside unlawfully in the United States for private financial gain, in violation of 8 U.S.C. section 1324A1A IV and 1324A1B I. As relevant to Mr. Hellman Hansen's conviction, a non-citizen who overstayed his tourist visa asked Mr. Hellman Hansen if he should leave the United States, and Mr. Hellman Hansen said not to worry, his adult adoption program would get the non-citizen U.S. citizenship. Then again, at trial, quote, Mr. Hellman Hansen testified that he told the non-citizen that it was the non-citizen's choice whether to remain in this country without giving a recommendation, end quote. And indeed, that non-citizen was then adopted, I guess, as an adult. I don't know the specifics of adult adoption and immigration very well, but this does kind of sound pretty remarkable. A similar thing occurred with another non-citizen that Mr. Hellman Hansen advised. And maybe this is a bit extreme, but also, we immigration attorneys advise our clients all the time about what they can and can't do and what is technically permitted under U.S. immigration law, which, as we all know, has many overlapping requirements and exceptions and rules and laws and things you can't do, and really it's just a mess. The district court judge told the jury that the jury could convict Mr. Hellman Hansen if the government showed simply that Mr. Hellman Hansen, quote, encouraged or induced the non-citizens to reside in the United States in violation of the law and knew or acted in reckless disregard of the fact that the non-citizens' residence in the United States would be in violation of the law, end quote. Again, reading that requirement broadly, such a standard might, for example, criminalize telling a B2 that if they overstay their authorized time, they will remain eligible to adjust LPR status through their U.S. citizen spouse. A correct statement under immigration law, but also arguably encouraging a non-citizen with B2 status to overstay in reckless disregard that there may be an unauthorized stay between the lapse of status and the filing of an adjustment of status application. Just saying. Which may be one reason why the immigration bar was so worried about this case. Then again, it seems like something illegal was going on here beyond mere advisement of the technicalities of immigration law. Mr. Hellman Hansen was convicted. The district court denied his constitutional challenge to the statute. The Ninth Circuit vacated that and remanded, deeming Section 1324A1A IV unconstitutionally overbroad under the First Amendment. The Supreme Court disagreed on Episode 166. It held that the statute, quote, properly interpreted, forbids only the intentional solicitation or facilitation of certain unlawful acts, end quote. So it was remanded back to the Ninth Circuit because the Supreme Court interpreted the statute narrowly to be constitutional. And now on remand, the Ninth Circuit vacated this specific conviction again. See, although the statute itself doesn't have a specific intent requirement, the Supreme Court reasoned in this case that, quote, transplanting the terms encourages and induces from the old soil of the common law brings along the traditional intent associated with solicitation and facilitation, end quote. Love it. So that means that there's an implicit requirement, as traditionally understood in the soil, that to convict, the defendant must, quote, specifically intend that a particular act be carried out, end quote. And that means that the district court should have required, as an element, the specific intent mens rea in the jury instructions. In layman's terms, the Ninth Circuit held that to convict, the jury needed to find that, quote, the government proved that Mr. Hellman Hansen intentionally encouraged or induced the non-citizens to overstay their visas, end quote. And that's a higher standard, and a bit of a sigh of relief for immigration attorneys everywhere. The district court hadn't required this specific intent below. To be fair, the district court wasn't blessed with the Supreme Court's decision yet, so it's going back for further proceedings. And that is United States v. Hansen. Next is matter of FCS, published by the BIA. Amended. The BIA slightly amended its matter of FCS decision from 3 weeks ago to clarify something that I admittingly was a bit confused about at the time. As the BIA now clarifies, Mr. FCS was indeed initially placed in expedited removal proceedings, which resulted in his receiving a credible fear interview. But when the asylum officer found that he lacked a credible fear and the immigration judge overturned that finding, Mr. FCS left expedited removal proceedings for regular old INA Section 240 proceedings. The BIA had initially reported that Mr. FCS was never in expedited removal proceedings. The BIA has now reached the same result, but it has made this important clarification. So here's the new official rule after being slightly amended by the BIA. And I'm not going to do the whole case summary now. I encourage you to go back and listen to episode 203. But to summarize it briefly, the regulation at 8 C.F.R. section 1240.17 that favorably permits late-filed evidence for non-citizens with mental health issues, quote, applies only to those respondents placed in expedited removal proceedings whose applications for relief and protection were first adjudicated by U.S.C. and who were then placed in removal proceedings under Section 240 of the INA, end quote. That's the amended rule. Agree or disagree with the holding, but that makes more sense. It's not, as I quoted from the BIA on episode 203, that Mr. FCS was never in expedited removal proceedings at any time. It's just that his asylum application didn't travel to immigration court following adjudication on the merits in expedited removal proceedings. He didn't pass his credible fear interview until the IJ overturned the asylum officer's finding. Why that matters is an argument for another day, resolved by the BIA at least in greater detail in this decision and the last one. So go back to episode 203 for the full analysis, I beg you. This seems to be the only change between the cases after a side-by-side PDF comparison. Which brings up a good point. Thanks for the reminder, Kevin. If anyone at the BIA is listening, and if you find value from this podcast, would you consider noting the changes that you make in decisions such as this at the top in greater detail? I appreciate your footnote 1, but some circuits actually say exactly what's being changed at the beginning of their changed decisions, and some line by line. And oh, what a blessing that is. Do what you like, BIA. I'll keep reviewing either way. And thanks for listening. And that is matter of FCS, amended. Next is Ortega v. Garland, published by the 7th Circuit on March 29th, 2024. This case was actually published last week, but I swear, it didn't appear on the 7th Circuit's website until Monday. Nice April Fool's gift to me. So we're going to call this one an episode 206 case. That's on you, 7th Circuit. And it's about government ability and willingness to protect. Mr. Ortega is from Mexico and has spent most of his life in Mexico City. As the 7th Circuit tells it, quote, Mr. Ortega and his family have experienced multiple attacks and threats of violence. When he was young, his father was murdered. While the perpetrators were charged and sentenced, Mr. Ortega later learned that the murder was ordered by his father's cousin, Tacho, who was a member of the Sinaloa cartel. When Mr. Ortega was a teenager and serving in the military, someone, who Mr. Ortega believes was sent by Tacho, verbally threatened to kill him and shot him in the leg. Mr. Ortega told his military general, who sent a captain-led escort to investigate the shooting, but the shooter had fled, end quote. After Mr. Ortega left the military, he began receiving threatening messages. He changed jobs, but the messages continued. His boss transferred him to a different location, but the threats followed him, as did an individual in a car one day. Mr. Ortega lost him, and police responded to that event, but no report was filed. The next day, Mr. Ortega was followed again, and had a gun pointed at him. He outmaneuvered the car yet again, and filed a police report, and detectives assisted him. But Mr. Ortega decided to come to the United States shortly thereafter in 2002 without authorization. He returned to Mexico in 2006 when his mother reported that Tacho was now threatening Mr. Ortega's son. And when he tried to re-enter by plane with a fake visa, he was ordered removed and physically removed to Mexico. But then Mr. Ortega entered again without authorization. He remained in the United States until 2021, all the while receiving threats from Tacho's associates. A driving offense brought him to the attention of immigration officials, as is so often the case, and DHS reinstated the final order of removal from that fake visa incident. Mr. Ortega expressed a fear, but an asylum officer didn't believe it reasonable, similar to what happened in the FCS case that I just discussed. An IJ disagreed, however, similar again, and withholding-only proceedings were begun. It's withholding-only proceedings because the final order of removal has been reinstated, unlike in matter of FCS, which I just discussed, which was just a credible fear interview, which therefore resulted in INA Section 240 proceedings, after Mr. FCS passed his fear interview. Anyway, back to Mr. Ortega. After finding that he had a reasonable fear, an immigration judge ultimately denied withholding of removal on the merits, believing that Mr. Ortega hadn't established that the Mexican government was unable or unwilling to protect him as withholding of removal requires. After all, at all times as reported by the Seventh Circuit, it looks like the police were trying to help Mr. Ortega, no? Plus, apparently Tacho was incarcerated in Mexico. The BIA affirmed. The Seventh Circuit believed the agency reasonable. As the court explained, quote, actions of private citizens, such as Tacho, do not suffice unless the government is complicit in those acts or is unable or unwilling to take steps to prevent them, end quote. To the extent that some country condition evidence shows that there is corruption and unresolved crimes in the Mexican government and police force, this evidence was too generalized, explained the court. And if nothing else, it was too generalized to overturn the BIA here. True, Mr. Ortega was employed by the Mexican government during much, if not all of the time that the police were helping him. And so he argued, that's the only reason that they were able to help him. But to extrapolate that it would be different now that he is not employed by the Mexican government was just too speculative to the Seventh Circuit. This despite the fact that it does seem that some pretty scary things happened to him. Remember, he got shot in the leg. Relying, as often occurs, on the deferential standard of review employed by circuit courts for reviewing such things, the Seventh Circuit affirmed the IJ and the BIA and denied the petition for review. And that is Ortega v. Garland. This podcast is sponsored by Driftwood Capital. Driftwood Capital boasts a 30-plus year track record, transacting on more than $3 billion in hospitality assets. Since 2015, Driftwood Capital has successfully implemented the EB-5 program into their development deals, helping more than 160 families find a secure path to residency through their projects. Driftwood Capital is a vertically integrated commercial real estate firm specializing in hospitality with dedicated acquisitions, development, lending, and management divisions. Their goal is to create long-term partnerships with its network of more than 1,200 active investors from the United States and abroad while targeting attractive returns. Driftwood's unique approach involves managing all aspects in-house, from developing renowned hotel brands such as Marriott, Hilton, and Hyatt, to managing their portfolio of more than 80 hotels in the United States. If you want to learn more about Driftwood Capital, check out the show notes. And of course, let them know who sent you. We all know the immense dedication it takes to be an immigration lawyer. You fight tirelessly for your clients, their families, and their futures. But let's face it, the administrative side of running a practice can feel overwhelming. Mountains of paperwork, endless calls, juggling deadlines. It can easily steal your focus and leave you feeling burnt out. But what if there was a way to simplify all of it? I want to tell you about FileVine, a legal case management platform specifically designed by lawyers for lawyers. FileVine keeps all case information centralized in one place. Plus, FileVine's immigration-specific tool, Immigration AI, uses the most advanced AI-powered technology to extract vital information from passports, birth certificates, and other essential documents and automates USCIS form filling through smart questionnaires available in up to 170 languages. Pretty impressive. FileVine and Immigration AI can give you back precious time and energy, allowing you to focus on what matters most, your clients and their cases. So if you're ready to reclaim your time and rediscover the joy of practicing immigration law, head on over to immigration.ai/immigration review. Links in the show notes. Are you tired of answering your own phones? Or of wasting your valuable time on unqualified consultations? Staffy Live is the only 24/7 live receptionist and intake service specialized on immigration law. Staffy Live specialists are highly empathetic, bilingual individuals who know how to deal with adversity, have a background in client care, and are trained to qualify callers by asking the right questions. Staffy Live goes one step ahead in only scheduling qualified consultations on your calendar and then doing follow-ups when needed. Staffy Live is giving a 15-day free trial for any law firm interested with no strings attached. To apply, visit www.getstaffy.com. That's GETSTAFFY.com. stafi.com and click on Get Started. Make sure to put in the code FREE. Links, of course, in the show notes. Our final case is a bit of a bummer from the Fourth Circuit. Shaiban v. Jaddou et al., published by the Fourth on April 3rd, 2024. This case is about adjustment of status and a federal district court's ability to review denials thereof. Mr. Shaiban is from Yemen and received asylum in the United States in the early 2000s. An immigration judge had initially denied and the BIA affirmed, but the Second Circuit, where I guess he was living, sent it back and the IJ then granted asylum. So that's a lot of litigation and investigation of Mr. Shaiban. Not only that, but the first time around in 2001, quote, the IJ ordered the Department of State's embassy in Yemen to complete a consular investigation into Mr. Shaiban's nationality and identity, end quote. Haven't even heard of such a thing happening. Maybe it was an older thing that IJs could do? Seems reasonable though, no? It's all relevant here because when Mr. Shaiban applied to adjust LPR status under the special asylum-based provision for adjusting in 2008, USCIS turned around and said, actually, we think you're inadmissible for the material support of terrorism for activities that you, Mr. Shaiban, did well before you got asylum during Yemen's civil war in 1993. Back then, Mr. Shaiban had apparently been a member of the Yemeni Socialist Party. Mr. Shaiban disclosed this in his asylum application, but he had not disclosed that he had been imprisoned during the Civil War. Unsure the relevance of that, but probably should have been disclosed. This decision is light on facts. In any event, USCIS denied on terrorism grounds, based on facts that predated the grant of asylum, and that would have precluded a grant of asylum, had they been identified during all of that litigation and investigation into Mr. Shaiban way back when. So we filed a federal court action against USCIS under the Administrative Procedures Act. The district court ruled in favor of USCIS. Seems that Mr. Shaiban primarily argued that USCIS was collaterally estopped from denying adjustment of status on the basis of these terrorism things, as the issue of his inadmissibility under the terrorism-related grounds was necessarily decided when the immigration judge granted asylum. But, agreeing with a growing list of precedent, the district court held that for collateral estoppel to apply to USCIS based on what happened in immigration court, the matter had to be actually litigated, which is a legal term that is now being interpreted to, actually discussed. And because no one ever brought up the terrorism stuff or the terrorism allegations during the immigration court proceedings, it wasn't actually litigated, said the district court. Even though it was necessarily litigated as a matter of law, it wasn't actually litigated as that legal term is being interpreted by courts now. Quick aside, the Fifth Circuit very well may have the most friendly collateral estoppel standard when it comes to the actually litigated prong amongst all the circuits. Amrola v. Napolitano from 2013, if I'm not mistaken, which I'm not because I looked it up again for your listening pleasure. Just how collateral estoppel applies when USCIS is trying to do something somewhat contrary to what happened in immigration court in the past is a very important issue, particularly in this Supreme Court age of distrust of administrative agencies that we find ourselves in. Unfortunately, though, we will not find out what the Fourth Circuit thinks. The Fourth Circuit believes that it lacks jurisdiction to resolve the issue. Something Oil never really argued for in this case, but that the Fourth Circuit held. See, there's a pretty good chance that if this was all regular INA Section 245A adjustment, the Fourth Circuit would hold that Patel in INA Section 242A2BI divests it and the District Court of jurisdiction. But this isn't Section 245A adjustment. This is INA Section 209B Special Asylee Adjustment. And Section 209 is not a form of relief enumerated at the jurisdiction stripping provision at Section 242A2BI. That takes us out of straight Patel territory. But to the Fourth Circuit, that meant that it needed to look at Section 242A2BII. That subsection reads, in relevant part, that circuits can't review, quote, any other decision, the authority for which is specified under this subchapter, to be in the discretion of the Attorney General or the Secretary of Homeland Security, end quote. Unless, of course, it comes to the court through a petition for review, meaning that it began in immigration court, which is not the case here. That's the jurisdiction savings clause at I&A section 242A2D. Recall that's not what's happening here because this is the lawsuit that began in federal court against USCIS. Reason of the Fourth Circuit, Section 209 adjustment of status is discretionary, which is true. To the court, though, that means that it now lacks authority, after all these years, to review challenges to USCIS denials of Section 209 adjustment. It doesn't matter that there is a legal standard that must be applied when USCIS denies 209 adjustment as a matter of discretion. The Fourth Circuit believes that Patel supports its holding here, even though Patel was not directly on point because that was a regular adjustment of status case covered by Section 242A2B, single I. Much of the reason why goes back to a devastating sentence by Justice Barrett and the majority that Justice Gorsuch and the dissent took great issue with, quote, the Supreme Court, in dicta, suggested that Congress may have intended to close that door on such review through Section 242A2B, and thus foreclosing judicial review unless and until removal proceedings are initiated, would be consistent with Congress's choice to reduce procedural protections in the context of discretionary relief, end quote. Supreme Court dicta is powerful stuff, and the Fourth Circuit is reading it broadly to take away rights of non-citizens. Mr. Shaiban argued that Section 209 adjustment is not discretionary, or at least the question at issue here is not. Whether he engaged in terrorist activity or not is not a discretionary finding or analysis. But reading Patel broadly, as the Supreme Court and the 11th Circuit intended it to be read, to be fair, the Fourth Circuit held that even initial factual findings can't be reviewed when tethered to a form of relief that Section 242B precludes from review, no matter whether it's subsection II or subsection I, said the Fourth Circuit. And recall, the Fourth Circuit is here finding that Section 209 adjustment is discretionary and therefore covered by subsection II. The court distinguished some of its prior precedent that would permit review, including, heads up, possibly review where all that's at issue is denial of an I-130 petition, and not the accompanying adjustment of status application. Seems like that's probably still reviewable in the Fourth Circuit. No discretion on an I-130. If you're curious about what terrorist activities Mr. Shaiban is alleged to have committed in the early 1990s, you're not alone. I'm with you. The decision doesn't say. So to get this issue resolved, it seems, USCIS will need to put Mr. Shaiban back into immigration court proceedings, where an IJ will decide his case for a third time, this time expressly reviewing a terrorism claim that ICE did not bring up in the first two times, and only if the IJ and then BIA rules against Mr. Shaiban will the Fourth Circuit review the issue, possibly. That's how the Fourth Circuit reads I&A Section 242, and specifically Section 242B, and the savings clause at Section 242A2D, as in dog. Rough stuff. Still an asylee, though, Mr. Shaiban. Exceptionally weird result, right? I think so. And that is Shaiban v. Jaddou, et al. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at imreview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.